Hi, I'm Rushi Patel. I'm the General Counsel with the Georgia Municipal Association.
I'm Allison Earls, Associate General Counsel with GMA, and we're so glad to have a chance to talk with everyone today about this very important topic. When we spoke with Dan about delivering this, we wanted to put this together in a short period of time for a short webinar. This is really an abbreviated description of the Municipal Courts Post-Ferguson 1 class that we teach. Rushi and I teach this class at convention training, and the next time we'll be teaching the full Municipal Courts 1 class will be on January 24th at the Georgia Cities United Summit. So we will dive right in to this. And the topic of this presentation is reducing the risks of litigation associated with municipal courts. And so what are the risks of litigation? Well, there's obviously the cost. You know, we're lawyers. We know it's expensive to defend litigation. There can be penalties. There can be all sorts of financial consequences of litigation over municipal courts. But one of the costs that is very high and is sometimes hard to capture is the cost of damage to the city brand. Inevitably, when you have problems with the municipal court, you have newspaper articles, and they all start with things like, Mary Sue is a grandmother of 10 who was on her way to volunteer at church when she was pulled over for having a dirty decal. Okay, and then it just gets worse from there. So there's a lot of negative press associated with municipal court problems. And this press isn't just local, it goes nationally. And there can be a tremendous amount of damage to the city's brand because of this. The city looks bad. Another very high risk of some typical problems with municipal courts is the dissolution of trust in the entire judicial system and in the police. The municipal court is the primary way that people experience justice. If you ask anybody if they've been to court, many of them will say, yes, they've been to court for traffic tickets, etc. And that's all their experience is about what it's like to face a judge. And if their experience is bad, if they feel that the deck is stacked against them, their whole belief in the way our country works is damaged. And so they will kind of check out in a lot of ways and say, look, there's no chance, I'm not going to get a fair shake, I'm not going to get a fair hearing, everyone is against me. And then another real danger of typical municipal court problems is public safety. When people perceive that the police are really not about protecting them and promoting public safety, but are instead trying to squeeze money out of them and trying to treat them as a source of revenue, they will stop calling the police when they need to, and they will not cooperate with the police. In order to have good public safety and a safe society, the police need to be able to trust that citizens are going to give them information. And when everyone hates the police because they associate them with fines and penalties and getting caught for all sorts of problems, they're going to stop cooperating with police. So those are some of the risks of litigation.
And to Allison's point, when they stop trusting the police are the face of the city for most people. They're the people that work for the city that they see the most. And so if they lose trust with the police, they're going to lose trust in the city itself, and that's a really big problem. So let's talk about some of the key actions to reduce the risk for the city and for the court. Well, one thing that we teach in the municipal courts classes that we teach, as Allison mentioned, we're teaching our next one on January 24th at the Cities United Summit, is that it is very, very important for the court itself to be independent. Now, we all learned growing up that there's three branches of government. There's the judicial branch, there's a legislative branch, and then there's the executive branch. Municipalities can sometimes blend those when you look at them, especially when you look at the executive and legislative branches. However, you should really, really treat the judicial branch separately. It's an independent branch, and it is important to treat the court independently. So the city officials in charge of your city need to know that that's an important aspect of the court that needs to be maintained. So how do we talk about this? Well, when we teach our class, we talk about how you should not have your court sitting inside the police department. The clerk of court should not be sitting inside the police department. Is that illegal? No, it is not illegal. Is it a bad idea? Yes, it's a bad idea. Why is that a bad idea? It's a bad idea because if I was a citizen and I had a ticket in your city and I had to go to the police department to go pay the fine, and I'm surrounded by law enforcement professionals, I'm going to feel very uncomfortable. Or if I went to the police department to go challenge the ticket and I'm surrounded by law enforcement professionals and having to go through the police department itself to get to court, I'm going to feel very uncomfortable, and I'm going to feel like the deck is stacked against me. So these are important things to reduce risk. But if people feel like they are not being treated fairly, they are going to have problems with your court, and there's a higher degree of risk for failures in the system for the municipal court. So couple things that you want to do when you're talking about independence. First of all, I just mentioned one, is making sure that the court personnel have a straight line that doesn't necessarily go through the police department. Now, police are very important, but they don't need to be supervising court personnel. The second thing is the budget. The budget of the municipal court needs to be independent, and it needs to be independent of revenue-based policing. And we're going to talk a little bit about this later in this presentation. And what are we talking about revenue-based policing is the court should not be dependent on the fine money that's generated from the court. If you have that situation as a fact in your city, you're going to have a problem, because people are going to look at the court and say, well, they're trying to pay their own salaries and their own budget out of my pocket, and of course they're going to find me guilty because they don't get paid if they find me innocent. So that is a big problem. And then lastly, for this slide, what do you need to do if you get a complaint? If you get a complaint from a civil rights organization, you should always, always, always respond. Talk to your city attorney, get that addressed as quickly as possible. But even more so, if you get a complaint from an average citizen who says that something has gone wrong in your process, don't ignore it until it blows up to a complaint from the civil rights organization or a letter from the civil rights organization. Address it as soon as you hear about it. And sometimes you're going to find out that there wasn't actually an issue, that somebody just, was upset about getting found guilty or having a fine or something like that. But you should always investigate as soon as you hear about it, because the longer you wait, the greater the risk to the city that the complaint will blow up into litigation. And as Allison mentioned, litigation is very costly.
And one point I want to distinguish between a complaint about a particular decision. It's not appropriate to go talk to the judge and try to get the judge to change the decision. That's not what we're talking about. In fact, that would be against the whole concept of independence. But if somebody is saying, hey, look, I didn't have money to pay, I was held without bail, and it's improper, you're not, to follow up doesn't mean you're second guessing the judge. You're checking out, hey, is this a pattern? Is there a problem? And talk to the city attorney about that. You would not speak directly to the judge.
That's right. Making sure the processes that are supposed to be in place are followed is very important. So what else are we talking about here? Well, when municipal courts in Georgia are in play, we're not talking about a lot of dangerous crimes. The most dangerous things that come through municipal court in the state of Georgia are DUIs and reckless driving. And reckless driving can bleed into some very high speeding offenses. But for the most part, we're talking about low-level offenses that are, maybe running through a stop sign and things like that. Now, don't get me wrong, there are very high dangers with those low-level offenses, but these are not crimes like murder and rape and things like that going through municipal court. I bring this up to talk about sign-own bond practices. Now, sign-own bond practices are things that we strongly suggest that courts look at adopting, because most of these criminal offenses that come through municipal courts are not offenses that the person poses a high risk of reoffending, and they're not things that would cause the city to become a higher danger if the person's back out on the street driving back to work or things like that. What is a sign-on bond? Well, it's basically the person comes into court and says, yes, judge, I will come back to court for my trial date. I'll sign my signature here as promising that I'll do that. And if I don't, you can hold me for violating this sign-on bond document. So that's what that is. It's basically the person making a promise to the court. And if they violate the promise to the court, they've violated a promise to the court. And that's a big problem. So let's ensure the procedures for determining indigent status and bail review within 48 hours arrest. We're going to talk about this a little bit later as well. It's been a big debate back and forth through litigation over the last few years of how long can a city hold somebody in jail before they get put before a judge. There's recent litigation the last few years in the city of Calhoun, which is in Georgia, that the courts have said 48 hours, at least in the 11th Circuit, 48 hours is the rule. And we're going to talk about the Calhoun case a little bit later. And so then the last thing we're going to talk about on this slide is reviewing the judge's compliance with their contract obligations and reviewing community complaints before renewing the contract with the judge. So in Georgia, we've had criminal justice reform, which we are again going to talk about in a little bit. Criminal justice reform over the last few years had a lot of positive effects on the court system in Georgia, particularly with municipal courts and minor misdemeanor offenses. So one of these positive effects was a requirement that judges in the municipal court are not tied to a political process anymore. It used to be that judges in municipal courts were at-will employees. And what did that cause in some situations is it caused judges to get fired when they ruled on a case in a way that maybe the elected officials did not like. And that is a big problem. As we talked about, independence of the courts is a really, really, really big deal. And so now judges in municipal courts are not at-will employees. They are required to have terms in the state of Georgia. And it's very important to have a contract with that judge. Why is it important to have a contract with that judge? Well, when you have a contract with that judge, you can set out specific things that you want that judge to accomplish in that year that or maybe your term is longer than a year. And what are we talking about things that we want them to accomplish? Well, we want to make sure that they're reviewing the probation company reports that are supposed to be turned over. We want to make sure that they're reading everybody their rights before court. We want to make sure that all forms are being signed. We want to make sure that the judge is doing all the things under the law that they are required to be doing. So some more key actions to reduce risk. There are two big contracts that you can find in our model publication on our website, which is gacities.com. If you look in the publications, there's two model contracts that you will find in our municipal courts publication. One model contract deals with probation companies. Probation companies is another big change we've seen in the criminal justice reform laws over the last few years. Georgia, unfortunately, for the last 20-something years, I think, has had a problem with a huge growth in private probation who has kind of had a free nilly-willy way of doing whatever they wanted. And Governor Deal, over the last few years when he was governor with these criminal justice reform changes, made it a point to make sure that probation companies and probation providers are doing what they should be doing under the law and not abusing the system to steal money from people coming through court. And so a probation contract is vital to your city because it sets out goals and responsibilities of that probation provider for your city. I already talked a little bit about the contract for the judge, but we're going to hit on that a little bit more. Again, these are both in our publication. The judge has responsibilities as well. And then finally, we have an affirmation statement, which is available it's in our publication.
It will be in our publication soon.
Yeah. But we have an affirmation statement that we've created that basically is something the judge can go through and the court clerk can go through and say, yes, we are doing these things. No, we are not doing these things, but we will start doing them going forward. And that way your court can be sure on its own to go through that system and make sure that it's addressing everything that it needs to do. Question?
Do we have a question, Dan?
No, that somebody just requested some information, and I'm going to.
All right.
And
so I will continue here. The publication that Rushi was referring to is called Municipal Courts: A Guide for Elected Officials, and it includes one of the most important parts is in the appendix, and there is a self-assessment checklist that we recommend that you take to your city attorney because it is reasonable to anticipate litigation when you find out the things that you're doing that may not be in compliance with the law. You go to your city attorney and you answer these questions and see where what you're actually doing differs from the best practices. And in that document, it will say which things are actually required by law and which things are best practices. There's also this judge and court clerk affirmation, and the two contracts that Rushi was talking about. So in terms of best practices, we already have an example of what not to do. You note that our training is municipal courts post-Ferguson, and that is because the Ferguson, Missouri Department of Justice report on municipal courts was like the sample of all the things not to do. And so this report sparked an overhaul of our training. There was a flood of litigation after Ferguson, and so it's important for every city official to understand conceptually what happened in Ferguson and what the Department of Justice said was going wrong in the municipal court system in Ferguson, Missouri. The main thing was that police were writing tickets to generate money. And Ferguson budgeted for a sizable increase in its municipal fines and fees every year. It planned, it said our goal is to collect more money in fines and fees when it was planning for the year ahead. Now, I like to compare municipal courts to libraries, right? Why do you have a municipal court? So that people get a fair hearing, so that they are only responsible for things that a court finds them legally responsible for. And you would not, the purpose of a library is so people can take out books and enjoy them and learn and all that. The purpose of a library is not to collect overdue fines on late books, right? The fines happen, yes, because sometimes people don't bring their books back on time, and nobody wants that, right? But the purpose of a library is not to extract fines from people who come to the library. Similarly, the purpose of a municipal court is not to extract money from people. The purpose of a police force is not to extract money from people and pay for City Hall. The purpose of the police is to promote public safety and good order, and the purpose of the court is to ensure fairness and compliance with Constitution and laws. But in Ferguson, this was all switched around, and the city officials were routinely urging the judge to generate more revenue through enforcement. And in fact, one of the problems in Ferguson, for the next slide, is that the court always compelled payment. There was no review of whether the person could actually pay the fine. And so the court primarily used its judicial authority as the means to compel the payment of fines and fees. And so instead of being the blind arbitrator of justice, the court was being misused and abused as a weapon to force people to pay bills, and this caused some terrible consequences. One of them was that it resulted in a total mistrust in the police department and in the city. And in fact, one of the stories that I think is the most heartbreaking is that a woman called the police because she was being abused. So it was a domestic abuse call. The police came, they stopped the abuse, but then they looked around and they fined her for having something for a city ordinance violation, because the police's mentality was, how can I get more money? And she said, I will never call the police again, not even if I am being killed. And that's the sense. There was a total breakdown. Nobody would trust the police, and it had completely fallen apart, and the consequences ended up being
Think
riots.
about the risk for your community if people no longer trust the police to call them when dangerous situations are happening.
Mm-hmm.
The risk to your community is massive.
Right. And so this is not just Ferguson, Missouri. This is widespread. It's these kind of practices of extracting money and people mistrusting the police. They are happening throughout Georgia. And the damage to the brand, I said, again, is national. One example is there was a video in a town in Georgia where the judge was videoed saying, if you want to go home today, you're going to have to pay this fine, even though the person could not pay the fine. That's flatly illegal. You cannot lock somebody up because they can't afford to pay. It's clearly illegal, and yet that's what he was doing. And that video got released, and there was national attention.
Just think about that. This country was founded with one principle there, that we do not have debtor prisons, and that effectively created a debtor prison.
Mm-hmm. And in fact, there was a whole string of litigation on debtor prisons. And so there are people, well, you'll talk about, there are people who are watching your courts looking for this. So another example of this, there's recently been litigation against Doraville. There's a Curved article, How the Municipal Court Money Machine Burdens City Residents. The lawsuit describes a reign of terror in Doraville, where special code enforcement officers prowl the streets with iPads, ready to document the slightest infraction. Citations were given to people who had left coolers on their carports or bikes in their front yard. And the lawsuit alleges that the city of Doraville violated due process by using its law enforcement and municipal court system for revenue generation. And so this is a new form of litigation. And
so this form of litigation, we gave you a few examples here, but it's growing, and it's growing massively. Who are some key players here? Well, you have some nonprofit organizations like the ACLU, Equal Justice Under the Law, Southern Poverty Law Center. But oftentimes they tie themselves up and work together with law firms. And so you have two different goals when you have these nonprofits and you have law firms working together. The law firms oftentimes are trying to get a judgment out of the local government, often the city. The nonprofits are often trying to get a change in practices out of the local government. I think the change in practices is probably something that we should be working for, and trying to avoid having to give up money to law firms. So when I mentioned earlier, when you hear from complaints or letters from these civil rights organizations, take them seriously, because the quicker you address them, the less likely you're going to have to pay out a money judgment, the less likely you're going to have to pay out litigation. There's a recent Supreme Court case called Timms versus Indiana from earlier this year, which basically says that the Eighth Amendment prohibition on excessive fines does apply to state and local governments. Why is that important? Well, that's important because that means that there can be litigation on your probation fees and your fines from municipal court that could violate federal law. And this could lead into a whole new round of litigation and a whole new slew of slew of litigation costs. And we already talked about Governor Deal's criminal justice reform. So I know we have only an hour, so we're going to move a little faster. So if the judge or clerk violates the law, the city will be sued. We mentioned some of these firms and some of these civil rights organizations, but I wanted to have you all see these organizations on a slide here. Let's get back to some independence issues. Independence in the municipal court. The municipal courts are independent of the mayor, council, and the police department. Now, Georgia law is a little wonky here. And Georgia law is a little wonky here because municipal courts are created outside of the provision of the Georgia Constitution that deals with the judicial branch. Georgia municipal courts are created by statute, not by Constitution, for the most part. There's a few that are created in the Constitution. And why is that important? Well, the statutes that deal with municipal courts are sometimes a little outdated, and they sometimes have language that can be confusing because they sometimes refer to municipal courts as mayor's courts or police courts. I'm going to tell you this right now, you are running a huge, huge, huge risk and probably violating a whole lot of laws if your mayor or your police chief is acting as the judge. Don't do that. So it's important to have the mayor as the executive and sometimes legislative functions, have the police chief as law enforcement functions, but have the judge as judicial functions and be independent. Have the judge and the court clerk and whoever else works for the court independent. This is essential to fairness and the perception of fairness. Again, I mentioned if people think the police or the mayor is involved, well, they're not going to feel like they're getting a fair shake. And honestly, your mayor shouldn't want to be the judge because if they want to get reelected, that's probably a bad idea. I'm just saying.
That's true. That's true. So let's talk about funding for the municipal court. It costs money to run a court that complies with all the laws. And one of the real risks is trying to have a court when you don't have enough money to run it properly. So one of the things every city should consider is, do they have enough money to run a court properly? That being said, it's important that the municipal court be funded from general assets. You do not ever want to have a situation where you are budgeting, as Ruchi had said before, the court from court fines and fees. The court fines and fees should go into the general city assets, and separately, the city needs to say, how much money do we need to run a court that has access to public defenders, that pays for free interpreters, that has, the prosecutor has everything that it needs to have, has a really good clerk, etc. So the decision about how much should you fund the court needs to be totally separate than how much do you think the court will gain in revenues. I just want to show you this recent article from Governing magazine that spotlights this practice of what is being referred to as citation instead of taxation, basically where cities are unwilling to raise taxes, and so they try to gain revenue through fines and fees. And if you look at this, Georgia has a whole lot of cities where I think more than 10% of their general city assets are coming from fines and fees. And
this is not a good map.
Right, and this is kind of like, the civil rights organizations and law firms are just going to look and say, oh, let's go put some of our people into the court in some of these red spots, and then we will proceed with our litigation from there. So something really to look at. We've talked about how the judge's term has to be at least 1 year. You can only remove the judge in the middle of the year for certain egregious behavior reasons. This is very important, especially there are now, under criminal justice reform rules, there are a lot of situations where the judge has to waive a fine because the person can't pay it or convert it to community service. And if you can't have a situation where the city officials are saying, well, that judge keeps letting people go without collecting fines. No, the judge has to follow the law, and the laws have changed to make it much more difficult to, extract money out of people who can't pay it. So they can only be removed in the middle of the term for certain specified reasons. So it's really important to, how does a city make sure that its judge is doing a good job? Because there's a lot of risks associated with a judge that is not following the law in his or her own courtroom. Yes, there is something called a Judicial Qualification Commission. So if you think that your judge is doing something really terrible, or if there are complaints, the complaint can be made to this commission and they will look at it. They will review complaints, they will discipline the judges. But the judge is a vendor. If the city has a contract with this judge that spells out what they should be doing. And so basic obligations of monitoring a vendor apply to the city. And I think a lot of times the cities haven't really thought about it that way. They've just been like, oh yeah, we just appointed this judge and the judge is just going to do whatever the law says and that's it. And we can't supervise them. Well, actually, if that judge is doing things that are illegal, you can terminate that contract after the year is over. And recently in the 11th Circuit reviewed a case in Teagan was the case, and there were a lot of really unpleasant statements by some of the justices on the 11th Circuit about what was happening. Cattle call, kangaroo court, and one of the quotes was, someone ought to tell the city to straighten out their court. Well, how can you straighten out a court while still maintaining independence? So let's talk about the relationship between the court and the city's governing authority. Certainly in the middle of the year, you can terminate for willful misconduct in office, willful and persistent failure to perform duties, habitual intemperance. But this is all very tricky because there are currently no rules about what kind of hearing the judge gets. And so it's pretty risky to terminate a judge in the middle of the year at this point. But you are able to review how the judge is performing under the contract. So
I think the key here, though, while it's risky to terminate in the middle of the year, do not keep a judge in office if they're doing something that is clearly in violation of one of these things, because you run a bigger risk by letting that happen.
Absolutely.
And I would like to point out that this list for removing a municipal court judge is the same list that exists in the Constitution for all other judges that fell under the Constitution. So it's not something special that applies to municipal court judges. It's just something that had not applied to municipal court judges because of a quirk in the law.
Right.
But now it does.
That's exactly right. So go to the next slide, please.
Sure, this one.
Dan, yeah.
Yeah.
You. So a judge can either be an employee or an independent contractor. The city always has to pay for the judge's training. And there are a lot of areas about running a municipal court that need to be allocated to somebody. And one of the problems is that a judge will say, for the amount you pay me, I'm just going to come on the days that I'm scheduled. I'm going to hear these cases and I'm going to leave. And there are all these other obligations, like who's going to review the probation company reports, who's supervising the court clerk, who is responsible for saying we need to upgrade software to have a better system. So what we recommend is that you go through the sample contract at least to make sure that you understand who's doing what, because if you don't spell it out, something's going to fall through the cracks.
And if something falls through the cracks,
the city will be on
the city is going to be on the line because you have the risk. So let's talk about the other important person in the court. And it's, in a lot of ways, this person is more important than the judge. And we're talking about the municipal court clerk. Why is the municipal court clerk very important to the operation of a court? Well, first of all, your court's not going to run without a court clerk, because the court clerk has significant responsibilities. They are responsible for turning in all the reports that are required. And what reports are we talking about? Well, they collect these fines, and the fines can be split a lot of different ways because of these state mandated fine add-ons. They also have reports related to license suspensions and things like that. Well, if you don't have somebody who's capable of doing this and who has been properly trained, and we're going to talk about that in a second here, court clerks, just like judges, require annual training. So if they have not received that, then, and they don't know what they're doing, then you are running risks, because if the court clerk accidentally sends somebody in for their license to be suspended and they should not have had their license suspended, well, then that person might get pulled over somewhere else or maybe in your city, and they might get arrested and they might sit in jail. And then you have a lawsuit on your hands, and that is a big problem. So we're talking about entries of disposition, reports for fines, collecting the fine amounts, responding to open records requests. This is important throughout the city. Open records laws apply to the court just like everybody else in your city. Now, there could be different exceptions that might apply to your court records, but the open records laws still apply to the court. And the court clerk is often the face of the court. A lot of times people only see the judge on the day of arraignment or the day of trial, but the court clerk is a person that sits in the front, that they come to pay the fine, or they come to ask a question about, hey, can I get this delayed, or can I do this? The court clerk is the face of the court, so it's important for them to have good communication skills. So when you're talking about the court clerk, some important quick questions to ask. Is your court budget high enough for the responsibilities of the clerk? They have to have all these documents ready. These are forms that the defendants have to sign or may choose to sign, more importantly, when they come to court, waiving their rights to a jury trial, waiving their rights to an attorney. Forms are important because if you don't have documentation that the person has done that, that they've been offered an attorney, that they've been offered this, that they've been offered that, when they are required to be offered them, and you don't have any documentation, you don't have any records, well, that becomes a problem for the court. So make sure the court budget is high enough for the court clerk to do their job. What happens with a case backlog? This is not a Georgia story, but last year there was a story out of the courts in the Bronx, I believe it was in New York City, where a gentleman, and it wasn't just one person, but the story was focusing on one person. This gentleman came to court and he had a minor marijuana misdemeanor charge, and he came to court and they had a backlog, so they pushed him to another court date. And he came to court and they still had the backlog and they pushed him to another court date. Well, all this time he kept coming back to court. He came back to court a number of times. I think it was over a dozen times. And they kept pushing his court date. Well, all these times he had to come to court, he had to miss work. And when he had to miss work enough times, he got fired. And this is really bad for a city. If you have a case backlog like that and it's causing people hardship because they're having to miss work, or they're having to get a babysitter, or they're having to do something else that takes money out of their pocket, it could lead to risks for the city because the city is not doing its job and getting on top of its caseload. And then lastly here on this slide, who supervises the clerk? We mentioned earlier that sometimes cities can put their clerk in a police department, and that causes issues because then people go to see the clerk and they feel like, I'm already guilty, I'm in the police department. Sometimes the clerk is actually a police employee, which makes it even worse. Again, none of that is illegal, it's just a bad idea. So let's talk about a transition here. Let's talk about there's a violation of law. What happens next? So say that there's no citation, and what happens next depends on the city's. Well, let's see. What happens next depends on the city's bail policy and practice. We're going back to the Calhoun case here. Yes. It's a hard transition.
Sorry about that.
That's right. So the Calhoun case that I mentioned at the top of the presentation happened a few years ago, and let's give you a little background here. A gentleman was walking down the street in the city of Calhoun, and he was publicly intoxicated, and it was the Friday before a holiday weekend. I think it was Labor Day weekend. And the police came and determined he was publicly intoxicated, and they took him to the jail. Well, problem arises here is the city's policies and practices at that point did not require the person to be brought before a judge within 48 hours. So this gentleman sat in the jail for 6 days before some attorneys caused a fuss and said, whoa, this is not right. And the city realized that it had a problem on its hand. 6 days is a very long time to go in jail without seeing a judge to see if you can actually afford bail or if you can be let loose on your own recognizance. Now remember, this gentleman was not a danger to society. he was publicly intoxicated. If he was a danger to anyone, he was a danger to himself by walking in the street while drunk. And that's it, right?
And I would say one thing that helps me understand this whole concept of bail is that in this country, you're innocent until proven guilty.
That's right.
Right? The reason it's so terrible is he has not been determined guilty at this point. Somebody arrested him, right, and yet he's being incarcerated, which is a typical form of punishment for a guilty person. And so just this whole concept that the only purpose of bail is to ensure that you will come back to trial where somebody will determine whether you're guilty, right, or innocent. So,
and this gentleman sat in jail for 6 days again, 6 days for a crime that if he had been taken to trial that day that he got arrested, I guarantee you he would not have received a 6-day sentence. He probably would not have received a 1-day sentence. But he sat in jail for 6 days because it happened to be a holiday weekend, and there wasn't a judge and there wasn't a policy in place that required him to be brought before a judge within 48 hours to determine whether he could be released on his own on a sign-on bond, or if he had some other thing that he had to do before he could be released. That's up to the judge to make that decision, but there was no judge involved there. An important point here is some cities are going away from money bail completely. You see here that the city of Atlanta and Mayor Keisha Lance Bottoms has gotten rid of money bail altogether. And why have they done that? Well, they're worried about risk. They're worried about the risk of people being held in jail for these minor misdemeanors. Again, we're not talking about felonies. We're not talking about those at all, but these minor misdemeanors, people being held in jail for failure to pay a bail or not getting in front of a judge in time to determine what a bail should be, if there needs to be one at all. So these are important things to think about, because cities can combine their approach of the 48-hour rule and sign-on bond, and a lot of cities do that, where most things are sign-on bond, but some criminal offenses, even these misdemeanor offenses, might require a bail. So that's up to the city's discretion to make. But again, the 48-hour rule is very important that you do not break it. So what happens when you get arrested? Well, you're usually taken to a detention center. It might be the city jail, it might be the county jail, but you're taken to detention. And it's important that this policy is in place that, again, as Allison mentioned, this person has not been found guilty of anything. They've just been arrested for something. Innocent until proven guilty. It's important that they be brought before a judge as soon as possible, but no later than 48 hours later, to determine whether or not they need to have a bail assigned, a bond amount assigned to them per the bond schedule that might appear before the judge, or their own discretion as a judge. The judge has that discretion. And if there is an amount that, they're not indigent or anything like that, or if there is an amount, which most of these cases, again, are minor misdemeanors where a sign-on bond might work. The important thing is to have a rapid hearing before the judge. I'm about to cough. So let's think about these bond schedules. There should not be a standard list of bonds that applies straight on for everything that falls into that crime. Now, could there be a list that says, here's a general idea? Sure, but the judge still has to have discretion to alter that. If the judge does not utilize or have that discretion, then you haven't created a fair system, and you run a risk of basically holding people in court or holding people in jail for violations, holding people in jail without being able to pay their fines and fees. I don't need them.
Okay, sorry. That's right. If you don't mind, I'll take over here. Okay, so again, the judge is supposed to make an individualized determination in most cases about what is required in order for this person to come back. And you can, the city, if the city has a policy and is complicit in enforcing something that doesn't follow this concept of an individualized determination, there are real risks of 1983 actions. Some people have responded to Calhoun saying, see, we got our 48 hours. No, the city of Calhoun changed its whole practice to create a set portion of sign own bond, and then ensured in that practice that if nobody was there within 48 hours, the people would be released. So
and I would like to note with the Calhoun case is that the Supreme Court decided not to take it up after the 11th Circuit ruled that the new policies, the 48-hour policies and the new policies of Calhoun were okay. The Supreme Court decided not to take the Calhoun case up. But there are other cases from other jurisdictions outside of the state of Georgia on these issues too. And one of them is going to end up in the Supreme Court. So this is a constantly moving target.
And in that case, it said that a bail schedule is okay as long as the first appearance hearing will be within 48 hours. So,
I think there are 2 more slides, actually.
Mhm.
More slides.
Oh, okay.
Let's talk about the sentencing power of the courts. So the courts themselves have a lot of ways to punish somebody who's found guilty of a crime in your city. The punishment does not have to be jail and does not have to be a fine, and it does not have to involve probation. The judge has a lot of discretion here. The judge can assign community service. The judge, well,
A
I thought
research
it was.
paper. Right, I mean, there's a lot of interesting things that happens that the judge can be a tremendous influence in a person's life. You know, when the judge hears what's been going on, he or she might order completion of GED, proof that you're going to your job on time. The goal is to find the punishment that's appropriate for that person and will best rehabilitate that person and be best for the whole city. And so it's really important to constantly remind city officials that the court is independent and the judge has the discretion. And you can't simply say, oh, but the fine for this is always that. It doesn't work that way. And especially with bond and bail,
Right.
The question is, how much is it going to take to make sure this person comes back? It may be that no amount of money is going to be high enough to have them come back, and it may be that a very small amount,
Right.
or simply just a promise will work.
That's why a judge is a judge. They have to evaluate the person. One important note here is that cities that have prosecuting attorneys have the ability to create a pretrial diversion program. And this could be very good for the city and for the person that comes before the court, because a pretrial diversion program allows the person coming before the court to admit to something without having it put on their criminal record if they follow the plans and procedures of the prosecuting attorney. And it allows the city to maintain that fee for running a pretrial diversion program without having to split it 10 different ways for fine add-ons. So that's really important. Something else to note here, in Georgia, we have punishment limits for municipal courts. Most offenses in municipal courts most state misdemeanor offenses can only have up to $1,000 fine or 1 year in prison, and ordinance offenses are $1,000 fine or 6 months in prison. Now, that does not mean that every offense that comes to your municipal court should be in $1,000 fine level. This is a discretionary thing for the judge to make a determination whether there's a fine at all or what that fine amount is. There are exceptions to that discretionary ability, mostly with DUIs. So Georgia municipal courts are capped in their fine amounts.
All right, so fines are a form of punishment. They are obviously not revenue. One thing that it's important to note is that a due process and equal protection under the law require the judge to determine a person's ability to pay fines and fees. This is because we do not have debtor prisons in this country. The judge must reduce, waive, or convert to community service if there's a reasonable probability that the defendant will be unable to satisfy financial obligations for 2 or more consecutive months. So there's a bench card. This is in the assessment, but this is the kind of thing you want to make sure the judge is doing and saying officially, yes, we are all on board. We know that the judge is required to do these things based on individual determinations of ability to pay. Best practice to avoid litigation. Some risks of litigation. risky practice for the judge to be sending people to a particular faith-based group. You want to have community service organizations that are approved agencies and that they are the ones who are supervising the person. So those are some ways to reduce litigation. I'm going to move on to requirements of probation providers. There's been lots of litigation about probation providers. They have in the past done a lot of things wrong. They have to comply with the law, and they are supervised by this adult misdemeanor probation oversight division. As a result, the judge and supposedly once a year, the city council is supposed to get reports about how the probation company is doing. Specifically, the probation companies now need to say, this is all the money we're getting out of these people. So it used to be nobody knew. Well, now the probation company has to report, this is how much money we got in drug monitoring, or and the judge has to look at that and say, well, did I actually order drug monitoring? If he didn't, then the probation company is stealing from these people because it wasn't ordered by the judge. Some of the settlement agreements for debtor prison cases involve eliminating private probation. So some of the risks of punishment to the city. Anytime somebody is incarcerated, that creates costs for the city. Of course, the cost of incarceration, but any medical expenses associated with that. If you got a pregnant woman who gets put in jail for violating something and she delivers, all that is on the city. There's all sorts of risks associated with incarceration. Any kind of forced work, if you are saying, well, let's have them go out and clean up trash. Well, if there are any injuries associated with that, there's a lot of risk there. Certainly any kind of if you're illegally threatening incarceration for failure to pay fines, that creates a risk. And of course, the terrible stories and the bad press. So we don't have much time left. I think we should probably want to talk about waiving rights.
Sure. So when we're talking about waiving rights, how do defendants waive rights in municipal courts, or in any court actually? Well, it has to be knowingly and willingly. So that means specifically that the judge and the court should not be asking everybody in the court that day to waive their rights in a big group mass.
Right. That would be a risk for litigation.
That would be a huge risk for litigation, because we don't know that each individual person, if you do it that way, knows what the judge is saying, that understands what the judge is saying. There could be people in that court that don't speak English. So the judge needs to have individual interactions with each defendant to make sure that that person has knowingly and willingly waived their rights. And I mentioned earlier that the court clerk will have forms. It's important that the judge has this interaction, and then if the person says, yes, I will waive my right to X, then you have a form as well that is related to that. So there's a record that the person waived their rights. That's very important. So let's also talk about some records of the proceedings. Now, municipal courts in Georgia are not a court of record, but that does not mean municipal courts do not and should not keep records of their proceedings. There's a big difference there. A court of record is basically it's a legal term, but recording your proceedings is a common sense term.
And it's required for certain parts.
It
exactly.
Is. The municipal court rules themselves require the municipal courts to keep record of their proceedings. So it's important to do that. And I always like telling this little joke in our municipal courts training class, is that back when I was a baby lawyer, I actually was a municipal court solicitor for a short while. I did not go to law school wanting to do criminal law. It wasn't my thing. But it was the recession, and I took that opportunity. I was terrible at it, absolutely terrible. The records can be really helpful for a lot of things. They're helpful because they keep records of what happened in the court. But for me, they were helpful because I had the audio recording and I could listen to everything I did wrong. And that was pretty useful, you know? So records are very useful for litigation, for reducing risk, but also for training.
That's right.
We got a question here. It says, thank you so much for this presentation. Can you cover the judge's ability to find a defendant in contempt of court for FTA? Hill 17.6 contempt charges bench warrant.
So yes, a judge can find somebody in contempt for failure to appear and
Right.
issue a warrant for their arrest. However, there have been changes to this where you have to notify the person
Via post.
via postcard. There was a lot of problems with people moving around, and so they don't know that they haven't.
Right. So Georgia
Showed up.
law now, one of these criminal justice reform changes that was made a few years ago was that the court clerk, when someone has a failure to appear, the court clerk basically sends a postcard to that person's last known address and says, hey, you forgot to appear. And they have 30 days to fix that problem before the process for having a license suspension gets kicked in. So the law has gotten a lot better there, because there's no point in throwing people in jail or having their licenses suspended if it's an accident that they missed their court date.
And one of the things that has also been done legislatively is that the new citation form that you can use specifically talks about capturing a phone number, capturing an email, and encouraging the capture of where's an address where you know you will get the message, right? You know, if your aunt will always get the message to you, you can provide that information, because the goal is to make sure that they know the information about when the court date is.
That's right.
So the last thing, we solicited a lot of information from municipal court judges about what we could tell elected officials. And they say the most important thing, fund the court appropriately to ensure that it has basic resources needed to run the court in accordance with the law. Public defenders, interpreters, the judges, and the court clerk training paid for as required by law, and then conveying to the court staff, probation service providers, and police officers that compliance with the law is essential to maintaining the city's brand and preventing lawsuits. And so we deliver that message to you. Is there another question here?
Do you know what the percentage of municipal courts are managed by?
I'm going to guess the answer is going to be no here, but.
Managed by police department personnel.
So we don't know the percentage of municipal courts managed by police department personnel. What I can tell you is that every time we teach one of these municipal court classes, there's at least one or two people, if not more, in that class, whatever class it is, that tells us that they do it that way. And I think we've elaborated a bit on why we find that to be a problem and why parties that might sue the city find that to be a problem. And so we don't have a percentage, but it's not a 0%. It's a good chunk.
And there have been a number of cities who have contacted us and have said, yeah, actually, we altered the organization structure. The court clerk now reports to the city manager.
Which is great.
And it turned out that the police department wasn't really doing too much supervision of the court clerk at all.
Right.
So it looked bad, and it wasn't even very effective. So to have the city manager oversee the court clerk ended up being a much better situation. Right. And you can also put something in your judge's contract that says certain supervision obligations are going to fall on the judge under that contract.
Mm-hmm. Should we go to the comment?
I think that, oh yes. If you have questions, this is our contact information, and if you would like even more of this, you can come to Municipal Courts 1 post Ferguson.
On January 24th.
Very good. Somebody had asked, where can I find a recording of this session? Again, this will be recorded, and I'll be sending it out to all of that are registered. We'll also be sending it to GMA to distribute as they feel appropriate. So thank you so much, very much. Does anybody else have any pertinent questions they want to ask before we kick off? Let's see. Thank you so much. Great info. We got great, again, have a great day. Thank you, Emily. Well, thank you so very much for attending. We really appreciate. Thank you both, Allison and Rushi, for your information. I think it's very valuable. We'll continue to stress this to our membership. If you have anything else, please don't hesitate to email them. I'm sure they'll be happy to answer any of your questions and get engaged with that. You guys all have a great holiday season, and we will talk to you later.
Thanks, everyone.
Thanks.